I don't know about you, but I always remember April Fool's Day. And you remember that, do you tell the joke in the morning or you tell the joke in the afternoon? And I remember many years ago, I persuaded a secretary of mine to send a false message to one of my solicitors to return a phone call. Of course, there wasn't a phone call to be returned, to a Mr. Barry Mundy. And of course, it was to the fish markets. I just couldn't help myself. It was April Fool's Day. Why am I talking about April Fool's Day in a video when I'm a family lawyer and a fertility lawyer? Well, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and thank you for watching and listening to the Australian Family and Fertility Law podcast. And if you're watching this on YouTube, please subscribe. But why I'm mentioning April Fool's Day is because April Fool's Day is a significant day about recognition of parentage of children born via surrogacy if they've been born overseas. Because there are provisions in the Family Law Act that really didn't have any substance until April Fool's Day 2025. Because on that day, the Family Law Regulations 2024 commenced. And what they do, there's a provision in the Family Law Act that says essentially this, that if you're recognised on the birth certificate according to the law of the Commonwealth, state or territory, or a prescribed overseas jurisdiction, then you're presumed to be a parent. So look at the birth certificate. If you're in the right place, then you're presumed to be the parent. Well, the problem was until April Fool's Day 2025, there was no overseas jurisdiction that was prescribed. So birth certificates only applied if the child was born in Australia. The child was born overseas, tough luck. And then on that day, suddenly there were all these overseas jurisdictions that were prescribed. And for the sake of surrogacy destinations have included India, Mexico, Canada except Quebec, and I've never heard of any Australians ever going to Quebec for surrogacy, the United States, Colombia, Mexico, Greece, the United Kingdom, among other countries. And then along came this couple, and the court case is called Ing Baso, who said, a gay couple, we've done surrogacy in the United States and we want to be recognised by the Federal Circuit and Family Court of Australia as the parents of our child born in the United States. They came before Judge Harland, and Judge Harland applied the changes. And it is no surprise that she said, well, you got an order, and there's my language, not hers, of course, you got an order in the United States that you were the parents, you were therefore placed on the birth certificate as the parents, and therefore, because the United States is a prescribed overseas jurisdiction for the purpose of this provision of Section 69, capital R of the Family Law Act, you are therefore recognised as parents in Australia. And Her Honour then made a declaration for the purposes of all Commonwealth law that they were the parents. Her Honour also made some very helpful comments, which is that children born via surrogacy are discriminated against. And that's true, they often are. And that the Commonwealth, in listing these various countries, were the ones that Australia considered to be reasonable and responsible places that we can trust their birth certificates. And again, that's my language, not Her Honour's precise language, but that's right too. And in doing that, we're upholding, and Her Honour referred to the UN Convention on the Rights of the Child, upholding the rights of the child to identity, including the child's right to be cared for by its family. So a short decision, but upheld this basic point that many of the children who have been born overseas via surrogacy are now their parentage is automatically recognised in Australia. There has been some push and some uncertainty that if you've undertaken surrogacy overseas, you might consider obtaining an order from the Federal Circuit and Family Court of Australia or get a parentage order, as can occur in New South Wales and the ACT. But have a look at the impact of this decision. If you have become the parents in one of those places that are listed in the schedule, and I've said some of those before, then you are automatically the parents, you're presumed to be the parents under the Family Law Act. So really, such an important outcome and really powerful in protecting the identity of the child. Thank you for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers. This is Australian Family and Fertility Law Podcast, and if you're watching this on YouTube, please subscribe. We love our subscribers. Thank you.